Okay, guys, the court for Brian Koberger started a little early today, which is unheard of. So I guess this Judge Hippler, is just on it. So we're going to go ahead and get started now instead of at noon. It was scheduled, but they started early.
Of pain and suffering happens in that window between 2009 and 2023. And I think the court should consider that and have that information. We also need to make a record in the...
Any rebuttal?
Your Honor, I would just note that the defense submitted an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
All right, thank you. All right. The court is, having reviewed the materials, believes that given the concerns about the current justiciability of the, or rightness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be that would allow us to discuss the issue. And so for the time being, I'm not going to Wolf, or Dr. Wolf, I should say, her testimony, the declaration, an appropriate proffer. I will hear the merits of the motion based upon that proffer next. All right. So let's hear that from the defense.
Thank you, Your Honor. I would ask the court for leave to supplement that declaration, the information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf. That's not contained in the declaration. And I would like to make that part of the record too from her. So if the court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
You can submit that, and I will then hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor. Then moving on to our argument, and I will largely not repeat what's in our brief since the court has had a chance to take a look at that. We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody. When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Say there's no means under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote unquote botched execution of Mr. Creech. It seems to me that was a incident wherein Mr. Creech, the execution really hadn't even begun yet in the sense that they couldn't locate a vein. I don't see how that issue is universal.
I would agree that Mr.'s the situation that happened to him was unique to him. I don't think he's the only person, and I'm not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical.
Since then,
they've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
I think that they're going to utilize a central venous catheter. In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal approving that procedure, as well as a recent decision by the district court approving that procedure. I think that's the difference.
And I think, looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward. Immediate history in Idaho. That's what I'm looking at when I'm standing before you, representing Mr. Koberger, and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bayes decision. When you think about it coming off in light of the Bayes decision, and you look at what's happened since the Bayes decision, we're going to talk about that a little bit later today when we're talking about evolving standards of decency. We'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built. They're
building it right now, as I recall, from the media at least, that the construction's actually underway. But I may be wrong about that.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out, too. If you read our statute, and the court just summarized it, it's lethal injection unless it's not available, and then it's going to be the firing squad. But the way that's written is that
not seeing results with just hair supplements? Nature meet the power of science with prescription hair
lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs. We can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose.
Sorry about the commercial, guys.
Additionally, the information that I think is really important to the court is to understand things and advances that have happened in understanding conscious pain and suffering. If Dr. Wolf had been allowed to testify, she would tell you that she relies on studies from 2010, a working group from 2010, and a book that was published later than that even, and that's post the Bayes decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist.
If your motion were right, and even accepting as true that the current means of execution are either unavailable or would violate the Eighth Amendment as cruel and unusual, how do you get around Buckwell? You've not provided a alternate means of execution.
Well,
and I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way. Execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition proceeding, provide a available or an alternate, I should say,
I would say, to Your Honor, that we're not at the place where we would have to make that decision yet.
Speak to the justiciability of the issue overall.
I don't think it does. And I think that the separation and the difference is that place where we're preparing this case to go to trial. We represent Mr. Koberger, who sits innocent man right now, but we're preparing this case as a capital case with all of the things that involves, all of the requirements that are upon counsel. Take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction and if there was a death sentence and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Koberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional? But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, I think that part of why you're saying you shouldn't have to comply with Buckwell, but it seems to me that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time?
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the method. We're decades away from that, if that were to even happen. But what I'm saying is I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years. And the way Idaho's doing it right now isn't really working. It's not a realistic option. I think to have him sit on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of your rights, I just don't think that the constitutional protections allow that to happen. I think that.
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe the Troop versus Dulles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety. It is fear. It is the not knowing.
To be fair, the Idaho Supreme Court ruled that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read that opinion, and I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No.
Commercial, guys. We got a commercial.
Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was here, until now, and what you're talking about for Mr. Koberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades to sit. And no disrespect to the anxiety Mr. Creech felt. I think that must have been horrible for him. But to sit for decades and wonder is a lot longer. And so I understand what the Supreme Court said. I did read that too. But I think it's different when you're just starting out here in this circumstance.
Okay. Thank you. Nine.
Your Honor, I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today, but I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that, because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe was hanging. And then after he was sentenced to death, the state passed a law, made it electrocution. And the U.S. Supreme Court said there's no post facto problem with that, because you're not changing the penalty. The penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that a scheduled execution to take place on November 3rd now that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individual Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this. And certainly not that it can't do this decades from now. And again, that gets back to the rightness issue. It may not. It may be some other method, but we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the rightness doctrine exists. I also want to speak just briefly on the Bucklew point that the court brought up. What I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment execution claim. Alternative is a requirement of all, and all is emphasized in the decision, all execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested today an argument what a proper alternative would be, which also gets back to the rightness issue, which is we don't know decades from now what an alternative might be. Maybe even decades from now on the method of execution, because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional, or the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it. If the state wants to pass a law and do the method that he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless there's any further questions, we'd ask that the court deny the motion.
Thank you. Any rebuttal?
Just briefly, Your Honor.
If your dream is to become a nurse, WGU's pre-licensure nursing program is here to help you.
So we're here with the prosecution and the state. Well, the state is the prosecution. My apologies. I'm trying to turn off my commercial. But we're here today, and the defense and prosecution are going back and forth regarding the death penalty in this case of Brian, the state of Idaho versus Brian Koberger. They are presenting arguments to Judge Hippler regarding the death penalty.
Overall picture and saying the Constitution from sitting in prison when there's not a real means to execute.
Do you
I
have any
understand.
case that says that?
I'm making an analogy with the troop versus duels and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about 2 pieces of legislation to try to make this work, and it just doesn't work. So we're in a position where I'm not with a client that has a death warrant, and we're talking about whatever they'll probably talk about with Creech, with how they're going to do injection. We're not talking about the marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these problems with executing somebody, and height, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out. That's the difference in our argument. That's it. Thank you.
Thank you. All right, court will take that issue under advisement, issue a written opinion with respect to its ruling. Next, I want to take up the objection to Professor Cover's testimony.
Your Honor, as the state pointed out in its written objection, Professor Cover's testimony is
Is it Cover or Cover?
I believe I'll defer to defense counsel. It's Cover.
Cover, thank you.
Thank you, counsel. Professor Cover's testimony in this case would largely center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony. The state cited to Ybarra in its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case where it was an almost identical argument, and the court found that it simply wasn't relevant, and also preclude Professor Cover from testifying on that basis as well. When the state received the PowerPoint that Professor Cover would be utilizing, many of these slides are simply excerpts from statutes. The PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her testimony would be, which is a constitutional analysis leading to her conclusion that Idaho statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis. Thank you, Your Honor.
Massa?
Good morning, Your Honor. The first argument that I'd like to address relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was that they wanted a robust discussion about other data analysis and have that come under the scrutiny of cross-examination. And so that's my state Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion to occur so that the data is and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study can explain it. The other point that I want.
Hold on, y'all. Got a commercial. There we go.
Underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen did was nowhere even close to what the study that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively narrow the class of first-degree murderers eligible for the death penalty. That's not a relevant legal analysis. The legal analysis is whether an individual aggravator does so, and that it excludes rationally first-degree from among first-degree murderers within that particular aggravator. And as I understand Hairston, it's just not a relevant issue. It's not a legally, it's not an issue that upon which the question turns.
Well, Hairston was decided
that I'm a trial court and not the Supreme Court.
I know, I'm sorry I interrupted you.
No, that's
Hairston
okay.
was decided in 1999, which was a long time before Hidalgo was decided. And so the United States Supreme Court has absolutely made the issue ripe and said we want to hear what the specific data is, and we extend the invitation for that to be done. The study in Hairston was framed as, did Idaho's method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and capricious
That was the claim of geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It was based on money and whether or not an urban
That's
versus
different from
non-urban.
the issue of what the relevant legal framework is with respect to whether or not the aggravators are overbroad or over-inclusive.
I agree, but before we get to even judge, which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard, and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which is a legislative function that looks at the statute and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly inclusive. It doesn't do it based on, in fact, she generalizes the aggravators as quote unquote the fuzzy ones, I think is what she called it. And then the, I can't remember what the name, the clear ones were.
Right. But it is her study is a good foundation when get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right. Is that the Supreme Court, our Supreme Court, has said that that's not the issue. When we look at whether the aggravators are unconstitutional as being not sufficiently narrowing of the class of persons or crimes available for the death penalty, specifically rejected a approach that is based on the cumulative effect of aggravators together. It said you have to look at individual aggravator. Right? Does it efficiently? Am I wrong about that?
I don't disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible. But it begins, Judge, with the definition of first degree murder. You start with the definition, which is very broad, of first degree murder.
Which is why the aggravators are required.
And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Culver's article.
No, that's true, but it still comes to the issue. You still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
It's part of the analysis.
I mean, everyone agrees the statute applies to first degree murders that are eligible is without more
Excuse me, guys.
unconstitutionally vague. That's why the court had.
I don't know why I'm getting so many commercials. YouTube must be trying to force my hand to pay for the premium again. I'm not going to pay for it again.
Right. So then the question, the court has said, the Supreme Court of Idaho.
I'll start paying for it once I get to 1,000 subs on this channel.
Is in other courts, not whether when you look at all the aggravators together cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first degree murders from it? Does it narrow first degree murders? And you look at those each individual and not cumulatively. My understanding is that Professor Culver's analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that, Judge.
I've read our law review article, and that's what she says.
That's the purpose of having her testify. I think that it comes in segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, pair it against what the result is for it being arbitrary and capricious. And when you're talking about our court, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
The other concern I have, I'll save that. I'm just now thinking about whether I need Dr. Culver. Why can't I rely?
You are the trier of that. You listen to, I believe, to make a reasoned decision. hear testimony and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, statute's overbroad, the aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, you know, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court, what her approach was. And it was different than what happened in Hairston years ago. And so for that reason, this court should hear that so that you can make a reasoned decision.
Your Honor, I'd like
Somebody
to
else
address the
coughing
foundation
other than
issue,
me.
because
Thank
even
goodness.
if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Cover's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case. And Professor Cover did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates this one in particular, and potentially others, as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that, in fact, that those aggravators did not apply. The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was labeled utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not, sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack. Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping. But again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases, making those determinations. So what's essentially happening, and this kind of brings us full circle to the to the legal analysis issue with all of this is that she's reviewing court records, making it a legal determination different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Rebuttal? Oh, actually, that was the rebuttal, wasn't it?
If you'd let me talk,
I will indulge you for,
Thank you.
my schedule is already shot to hell, but we'll indulge you.
Judge, we will be able to get through in one day. I think that what the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. When an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used those records, why the conclusions she drew were drawn. You have, first of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data. Or if she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And so.
And that law review article was as of 2019?
Yes. Yeah. Yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So you, since I have you, you brought up Hidalgo, and you talked about the Supreme Court doing this. My reading of Hidalgo is it sure was denied. A minority of justices issued their own statement to gather additional information. The court itself did not. Am I correct about that?
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. Other states have done the same at the invitation of the Supreme Court.
An invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted as an invitation.
So I don't find the proffered testimony of Dr. Cover will be relevant or helpful to the court to decide this issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of what that testimony would be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of law. Whether to allow expert testimony is committed to this court's discretion, specifically the well-known 4-part My Fun Life standard. Opinions as to the law are generally not admissible by experts. The court is the determiner of questions of law and not what somebody else's opinion of what the law is. Opinions of what the law is are received by the court through counsel, not through expert witnesses. And so generally I would not have permitted expert conclusions about the law. And therefore her opinions are neither relevant nor helpful and therefore not admissible. Importantly, of course, as we've talked about, Idaho has opted to satisfy the constitutional narrowing requirements from the U.S. Supreme Court through the adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant, as I understand from reading her article, Professor Cover's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders, which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is individual aggravator provides a distinguishing between those who deserve the death penalty. The Hairston case, I believe, makes that clear. The court is bound by binding precedent of the Idaho Supreme Court on this issue. Therefore, I don't feel the need to take Dr. Cover's testimony. I think the issue is sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up, I certainly can Dr. Cover back at a later date to provide that information or to help clarify some of that information. So effective, I don't think Dr. Cover's testimony is needed this morning. Now, I'm not going to preclude the argument on the merits using Dr. Covert's, on that as well. And so I will hear arguments of the motion to the aggravators at whole. This is not the argument on the individual.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. We will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
your argument doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation is in the selection phase.
That's what I'm
so
saying.
I'm not arguing about that. I'm going to step and grab my water.
Sure.
I want to be clear about the argument and eligibility that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover
excuse me,
concluded that when you analyze the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a bind.
Open the door to managing.
Hold on, guys. We have a commercial break. What do you guys think? Do you guys think Judge Hippler will give him take the death penalty off the table?
My question was more a legal one, which is
Why is my sound crackling like this? Can y'all hear me?
analysis by Dr. Cover in her extensive law review article takes as its
Mic
starting
check, mic
point that you
check.
have to have a statistic below that identified by the two justices.
My check 1, 2.
Furman.
Your Honor, I guess I disagree that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I know that we have a line, Supreme Court.
There, I fixed it.
And Idaho's is worse. So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls with that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then it's arbitrary, that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors. And I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of 2 or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or other officer. So that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Lipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the ability phase. The other point that I want to make about our motion on this is the issue of geography, and I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harrison over financial resources. And the point was geography. It was in the context of arbitrary and capricious and not in the context of equal
but
protection.
as I understand your analysis is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's statutory scheme.
There are a lot of temptations facing young people today.
Now, for those of you who do not know, Brian Koberger is being represented as public defenders in the state of Idaho. Is a capital defense attorney, certified. So she's a certified unaliving penalty attorney.
Consideration, how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Interesting. I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho.
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside the control. Well, I suppose not really outside the control of the state, but because of the state's failure in discovery. This case, and then I believe there was another one up in the 2nd district relatively recently that was resolved.
And I can't dispute that. That still does not eliminate the fact that in Harrison, Dr. Jensen concluded that there was a geographical issue, and in Dr. Cover's study, she made observations about geography as well.
And she's confessed she had conclusions based on that.
That was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study was conducted in 1995 in Harrison has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Harrison is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. for those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If
names.
I go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at the cases since 2019 as well?
I think, Judge, the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Legal conclusion, looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today, and not as of 2019.
Yeah, I guess I'm not willing to concede that. And if it was something that needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
time
opinion
frame.
about that. She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is, if I were to engage in that, it seems to me relevant, at least as to the state claim for, claim that the state equal protection, not state equal protection clause, but the equal protection as applied within Idaho geographically. Would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but if you're taking the data from Hairston, which was 1978 to 1995, and Professor Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their. I haven't analyzed it. We could have that study done, but I think that there's enough guidance with all of those. Data to conclusion that it's arbitrary and
Given that he's from one of the smallest.
Restream is doing that, guys, chopping up my audio.
Then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time another.
Okay, Restream is chopping up. I see an error message, so I'm pausing. Testing. Testing. Okay. There we go. It's back.
One's charged with, and those costs at the time that he was charged. I mean, now it's different. So, yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that. But I don't have a case to point you to exactly. I don't think that has been it hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logston has raised this issue, so I don't want to say you're the first, right? But it has made it to the Idaho Supreme Court appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that, because one of the geographic districts you claim is does not get its fair share of capital cases.
And we did not submit that argument in our brief.
All right, thank you. I think you've used your time.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said this just isn't how you do the analysis. You don't accumulate them and then do.
What's intellectually wrong with that analysis, though?
With accumulating and then.
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is make the death penalty less arbitrary,
Correct.
Why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody.
But if you have so many aggravators that on the whole would essentially apply to any first degree murder, then isn't it just left essentially to the prosecutor as to which cases are or aren't worthy to bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly it's binding precedent. The defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today, and the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason, and that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were in Hall, they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrow requirements of Tulipa as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Harrison, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence the discrepancy that appears to be shown by Dr. Jensen's study
Like me today, y'all. Restream keeps jacking up my stream, y'all. Please bear with me.
this goes back to a problem of this whole
It keeps muting the sound.
The aggregating factors and then doing a mathematical study and finding a percentage. Because let's engage in that conduct, and let's say the courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factor. So now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there anything that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these. Unless there are any questions, we'd ask the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Harrison decision.
It's not necessarily a requirement you do, so I just wanted to know. You were fairly summary about it. It seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. So in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, that the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first-degree murders committed there, and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions, thank you, Your Honor.
Rebuttal.
Judge, I just wanted to touch on the issue that he raised about Hairston and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction, because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is, I just wanted to point out some of that mitigating language that I'd referenced. Tulepa that's in the statute that years in Hairston in 2002 and 2019 for Professor Covers, that's 37 years worth of data with the same definitions. So, instruction in a few more years, you've got 37 years to rely on. There's no narrowing. Thank you.
Do you know what year the Capital Defense Fund was established?
It was after 95, and I think that Hairston may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that. I don't. I just know it was after 95.
The issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not, and I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first-degree case, because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you.
All right.
I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we adjourn after that.
All rise.
Okay. So the judge is going to consider their arguments. Not really sure if he's gonna hold on one second, y'all. Let me let the system get back to me. Okay, there we go. So he is going to consider their arguments. Don't know if he's gonna come back today with a decision. This, of course, is a major decision in this case. Brian Koberger is accused of quadruple unaliving 4 young, vibrant college students in Moscow, Idaho. And he is currently pending trial. And his attorney is working very diligently to get the unaliving penalty off the table. Guys, what's your opinion on the unalive penalty? Do you think it should be applicable in this case? Sort of like, the old adage, an eye for an eye, because Brian Koberger is alleged to have committed quadruple unaliving. Let me know what your thoughts are on this. This will be a huge turning point in this case if his attorney is able to get this off the unaliving penalty off the table. As you heard in her arguments, she is submitting things to the Supreme Court, the higher court, because she has a few motions and filings that the judge has either outright denied or is still kind of considering or just disregarded. So she is fighting hard for Brian Koberger's life and his liberty. I will keep you guys posted as it relates to this case and any updates. And once the judge makes a decision, if he does like an oral presentation for his decision, I will be back live. It's his decision. I'll probably post it on my community wall and let you guys know what's happening within the case. But guys, definitely chime in on this conversation. Hop in the comments, let me know your thoughts. And if you're not already subscribed to the channel, please consider subscribing today. Be sure to set your notifications to all so that you're notified when I go live or add new content. I will be back. And you guys have a wonderful morning, afternoon, or night based on wherever you're tuning in from or the time of day that you're viewing this video. Thank you guys. Until